Hey, Carl Rominger here. 540-0580 is the talk line number. Woo! What do we got to talk about? Lots of stuff. All right. Well, I'm done with that other case pretty much now until sentencing, so let's forget about it for a while. I don't really care about it. Let's just move on for the moment. We're on to bigger and better things. Things are going to more directly affect your life. Health care. Yeah. Everybody thought, that they could count on John Roberts. Well, not everybody. Recall? Anyhow, I'm not going to toot my own horn too much on that one, but I called it. I was worried about it, and I had a theory on it. I do think, however, the fact that he reached out and called it a tax while sustaining it, and if you read some of the opinion where they talk about the fact that just because legislation is not necessarily wise or good, the constitutionality is a separate question. That's kind of gratuitous. That's kind of gratuitous in some ways. The Supreme Court didn't have to lay it out exactly that way. And when Roberts did, I think he was trying to tell you something, that he doesn't agree with the legislation, that he isn't going to have been the guy who supported it. But that's my theory. He just sort of threw it out there so we'd all know that he supported the constitutionality of it, but not the legislation itself. Jim, you're on the air.
Yes, thanks for taking my call. And I've got a little bit of a problem. I haven't heard from my lawyer in about 3 months, and I started leaving messages, and I never got a call back.
Okay.
And I called his office, and I visited his office 3 times to tell him that, that they're fired, and I want to get my file back. Now, this has been since the end of March, and I still haven't heard back from him since I last talked to him on the phone was June 18th. I was wondering, what do I have to do to get my files back from this attorney?
The short answer is I would consult a second attorney to have them contact them to find out. In terms of the files, if you gave them materials, then they should be able to return those to you. If, on the other hand, they have a file on you, then they need to give you at least a copy of it. They probably want to maintain records for their own purposes. So, for instance, I have records of past files only because if a client were to come back and say, hey, you didn't do this or you didn't do that, I can say, well, here's you wrote when I asked you, was there a pension in that divorce? And you said no. I relied on your representation that you didn't have a pension, so that's why we didn't think about it. But yeah, no, those should be returned to you.
So, and like I say, this has taken since forever. The first time I told them that they were fired was back on May 29th.
Now, is it an ongoing case? Is it something that needs to be done at this point? Is there a deadline looming?
No, I don't know because nobody's told me anything. I haven't heard from the lawyer since March 23rd.
Okay.
So I don't know what's going on, and I can't get my files to find out.
Jim, what I want you to do is hit me up off the air, and then I can go forward with that. Jay.
No, oh, sorry.
Didn't you expect to get on?
I thought you said hey.
Hey.
Actually, I got a question or a comment, not about the Supreme Court decision. I don't really understand this. I don't know what it is, paranoia or whatever it is about any kind of this decision. I don't think it's the end of the world, one way or the other. But obviously, a lot of the callers in WHP land do. I was listening to Durgan the other day, the day this came forth, and he had an attorney from Philadelphia, supposedly a constitutional attorney. Didn't seem too bright to me, a guy named Rossi. And somebody called in and said, what is it, a new court could overturn this? What does a new court mean when somebody dies or retires? And I know what that means, but what this lawyer said, well, it would be good if John Roberts dies. Now, please. Well, I know you lawyers don't want to jump on other lawyers. That's literally what the guy said. I listened to it again.
Well, okay, now wait a minute. John Roberts was everybody's friend for a while, right?
He was justice. Well, he's not my friend. He's a justice.
And now, what I'm trying to say, though, for our listeners out here, when he was approved, and I recall thinking, because I understood his background, I think, a little bit differently than maybe the average person. He was pushed through as, a conservative.
Well, so was all Warren.
Well, a lot of people listen to the radio. Right. And a lot of people listen to the radio just think that means something. They don't understand that a judicially conservative philosophy includes things like strengthening Sixth Amendment and making it harder to put criminals in jail. That's what Scalia and Thomas and some of the other guys have worked on, and they've given criminal defense attorneys a series of very positive decisions that make the government's ability to convict people much tougher. So when John Roberts does something like this and jumps ship in their minds, they don't understand that, no, he's being completely consistent with a judicial philosophy that he said that he had from the beginning. So if you supported Roberts at any point, you've got to support him in this.
Well, as I said, I understand his ruling or his reason, if you will, and I'm not necessarily against this law. I think there are probably good things and bad things, and because we're in such a political fervor of today, we foam at the mouth, especially people that listen to political talk shows. One side or the other. I have liberal friends on Facebook. I mean, people were defriending each other because the liberals are acting like they won a football game. It's not all one way or the other, but all these people think it is. They think it's all one thing or the other.
Okay, so here's my favorite. If you're completely opposed to socialized medicine and the federal government shouldn't be in medical care, yada, 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 then get rid of Medicaid and get rid of Medicare.
Right.
But everybody and their brother who's over a certain age, whether they're Republican or Democrat, is not going to give up that benefit or even be willing to phase it out, best I can tell. So this is the type of entitlement that will eventually become popular en masse. It's also going to bankrupt the country eventually, but that's okay.
That's possible. I don't say it's good. I'm just saying what got me is here's a lawyer, supposedly a constant. Now, if he would disagree with, I guess they look at this guy like he burned the flag. I just don't, which is legal too. It doesn't bother me that much.
Right.
Because it's. I know what a lot of people think it stands for, and it does stand for that, but it's...
Well, look, at the same time the Supreme Court upheld health care, it struck down the Stolen Valor Act.
Right, that was, to me, a silly law.
You can lie about your military medals. I mean, I don't think it's a good thing, but I'm just thinking about all the times you've been around and you start listening to people like, oh, I ran a 5-minute mile, and you're looking at the guy and going, oh, there's no way that guy ran a 5-minute mile.
Right.
And I've known a few compulsive liars over the years, and it's interesting too. I agree it's a bad thing to do, and it's morally reprehensible, and these people who pretend to be military heroes and undercut other people's legitimate credibility don't deserve our love, but I'm not necessarily sure it's criminal, and that's, I think, what the Supreme Court agreed with.
Well, I don't keep you. I was just a little shocked. I may even write to the guy if I can get, because that's literally, I don't know if he thought he was making a joke.
He may have been just making a joke, and, listen.
When you're in a political talk show, like Durgan's show, I guess you play to the audience, maybe.
Hyperbole. All right.
So, okay, thanks.
All right, Jay, take care.
Bye.
540-0580, Carl Rominger here answering your legal questions. Going to make fun of Deadspin in a little bit here. Art probably is a big Deadspin follower. 540-0580, we'll talk to Bob when we get back from the break. Welcome back, Carl Rominger here answering your legal questions. 540-0580. Bob, you're on the air.
Hi. I guess I am too concerned about the Obamacare decision, but not the Obamacare part.
Mm-hmm.
My concern is that once you've said that, it's a tax, therefore it's okay, you're taxing people for doing nothing, essentially. Where does that stop? They talk about, can they force you to eat broccoli? Well, it sounds like they could. They could tax people that don't buy broccoli. What if, as I read in an article the other day, what if somebody wanted to improve housing starts, construction, whatever? So he said, everybody that makes over $500,000 or $200,000, whatever, needs to buy a second house. Now, you don't have to. It's not a mandate, but if you don't, we're going to tax you X amount. That seems to me the decision seems to open the door for anything like that anything can be demanded, any active activity can be demanded on the pain of a punitive tax.
And I think that's the next logical step. I mean, now, there's going to be some argument that the healthcare situation is unique and it's special. But unique and special are adjectives that have been used to describe a lot of different things by anybody who wants to claim something's unique and special. So it is a terribly slippery slope, and quite frankly, it might be a correct constitutional interpretation such that if Congress creates a scheme that always, and the end result is it's a tax that causes things to happen a certain way, then the courts are going to uphold it based on this decision. Absolutely.
Like I said, I think that's far more concern than the Obamacare part.
Yeah, no, I don't disagree. Now, the theory is at some point there's a political solution, which is throw the bums out.
Well,
which means elect people who won't pass these things. But representative democracy is tough.
And the tough thing that was, I believe, Jefferson referred to was when you pass a law or anything like this, you don't want to be dependent on the goodwill of people in office. It needs to be read in such a way that when people with bad will get in office, they can't use it as a weapon, and this does not meet that cut.
Well, that's the other problem now. I mean, here's the answer. What you would interpret as bad will and what I would interpret as bad will might not always be the same thing. And so, right now there's some guy sitting around somewhere who's sure that the government should be, doing something heinous to somebody somewhere who would think the fact that we're opposed to it means that we don't have the country's best interest at heart. So those are strictly political questions, and what the court was trying to say is, we don't decide whether the politics of this are right or wrong, or that the decision makes sense, or it's even in your best interest. The only question is, can we find a way to maintain it under the Constitution? But you're right. This may become the case. I want you to think about this. McCulloch versus Maryland? Was it and some of the early cases where we get the concept that the court is responsible for looking at the constitutionality of these questions, right?
Mm-hmm.
If we've now reached a point where all Congress has to do is use the magic words, it's a tax, and they're no longer subject to review, essentially, then the Supreme Court has just abdicated a position that it took at the beginning of the institution of the country.
Yeah, Marbury versus Madison, yeah.
Yeah, Marbury versus Madison, and then I agree. So, long story short, though, that's the position the court gave itself. I guess the court could abdicate it for itself, right?
I suppose there's a couple hundred years in the middle there.
Right, a little stare decisis issue. But no, seriously, I mean, think about that for a minute. So this could become a watershed moment in American jurisprudence, because if this decision is read to allow anything that ultimately can be called a tax to stand, then all Congress has to do is use the right magic words and say, hey, we don't really care which of our powers this is under, because essentially at the end of the day we're trying to create a tax here.
Exactly.
Yeah, interesting. All right, my friend, good point.
Have a good day.
540-0580. Ryan, you're on the air.
Hi, Carl.
Yes.
Hi, Carl. My topic really doesn't have anything to do with the Obamacare and the
It's
policy.
okay. You got a legal question? Shoot.
Okay.
That's why we're really here,
It has to do with estate laws. My brother had passed away this past Christmas, and my parents, they signed to take over his estate. And, my suggestion was, I think you're going to need a lawyer for the future, and obviously they do. Now, businesses, banks, and people he owed money to are coming after them. Now, my parents' concern, because they did get my brother's life insurance policy, but most of that went towards the funeral and the burial.
Right.
There's not much money left. Now, these people that are coming after my parents, the brother's estate, my parents are afraid that they're going to have to pay their own money for money that he owed. Is that true, or is that something that's not going to happen?
They should not pay any of their own money, nor should they agree to assume any of his debts. Yeah.
Okay. So the best advice right now is just to obviously get an attorney and go from there.
Right. Wrap the estate up.
Okay, because these people are, making phone calls and scaring my parents and, saying you owe this,
I've seen that many times.
Okay. All right. So really, I don't really think there's anything that they have to worry about. It's just get an attorney and go from there.
Correct.
Okay.
All right, brother.
All right.
You answered your own question. How's that?
Oh, yeah. Hey, can I have your number to your office?
Yeah, the office is 717 241 6070. So it's 717 241-6070.
Thank you, Carl.
And you guys can look us up at on the web at Rominger Law, ROMINGERLAW.com, RomingerLaw.com as well. All right?
Hey, I look forward to contacting you.
All right, Ryan.
Thank you.
Hey, thank you. 540-0580. Carl Rominger here answering your legal questions. Of course, we'll be live on the air until 3 o'clock working away on these things. So if you got one, call in now. But if you're driving around or you want to think about it or you're not sure or you just want to listen for a while but you do want to ask a question, feel free. I mean, I want to get you on here. This is your chance to get a quick thumbnail. You know, do I need a lawyer? Do I have a problem? Should I be talking to a lawyer or is it something I don't have to see a lawyer about? Well, I'm here for 2 hours every Saturday, and I've been away for a couple weeks, as you guys know, so I have missed you, and I've not been able to answer all your legal questions. Hope we can get caught up here. John, you're on the air.
Hi, Carl. I love your show.
Thank you.
I have a sister who is on SSI, and she's partially disabled, and she was gifted some money, and that money was actually put in my brother's name to, I guess, hide it from SSI. And he went AWOL with the money. It's been like 14 years now that he's been in possession of the money. It was put in CDs for investment, yada, yada, yada. But recently he went AWOL with the money, and just wondering what our recourse is.
So he went AWOL with about how much money, can I ask?
It's $8,000 to $10,000, and we're not exactly sure.
Okay. And do you have the ability to find him or get a hold of him at this point?
Well, we know where he's at. He's actually upstate, working in the gas mine, gas drilling.
Right. And you
in that area.
You think the money he ran off with he's still going to have? Or
there's potential to come back, I'm sure, but the kicker is he's in the middle of a divorce also, so kind of complicates things. So,
well, I think the first answer would be to send him a demand and ask him to pay up.
Okay.
And if he refuses, then I think the next step is to pursue him with a lawsuit.
Okay, in small claim?
Yeah, I would start in small claims, and you could sue him for where the money was taken from, which would be down here, right?
Yes.
So you don't have to go find him.
Right.
That would be my advice.
Okay.
It's small enough because it's under 12,000, so it'd be under the jurisdictional limit. Just thinking this through. Obviously, you can appeal that, but maybe that'll at least get the process started, and you can drag him in and get him interested in maybe making right to the family.
Yeah. He actually is refusing to answer any phone calls.
Right, so now you got to give him a little smack.
Yeah.
All right, brother.
All right, thank you.
Good luck.
Love it. Bye.
540-0580. Jerry, you're on with Carl Rominger here on WHP 580. What's going on?
Hi, Carl. Good work in your past endeavors. I'm sure you know what I'm talking about. But I had a question. I realize the case is going to be up for appeal, and I know you can't talk about that, so I want to ask you a question in general.
Yeah.
In a situation that occurred, is it normal for not to request could a judge in that possibility commit reversible error relative to not requesting or not granting a change of venue or not granting motions under discovery for something like that happened relative to the evidence? Anytime
a judge errs as a matter, we'll back this up. Anytime you're in a court case and a judge commits an error, it's subject to appeal. And so the answer is we have different standards, and we have a few different ways to look at it. So here's what I want to do, Jerry. I know you're on a cell. Would you be willing to do this? And I'm gonna drop you, and then after the next break, I want to go through the whole concept of an appeal and judicial error for folks.
Okay, that's fine. I appreciate that.
Yeah, will you'll be able to hear me, won't you?
Yeah, absolutely, sir. All
right. Hold on. I'm gonna drop you, and then I'm gonna pull you back. I'm gonna talk about it after this break that I'm gonna take in a minute.
Thank you, sir.
All right. So when we get back from the break, I'm kind of giving you guys an overview of how an appeal works from the concept of what it is that we do on appeal or what we're going to argue. Just a general overview. But his question was such that I feel like running into the break, I would only be able to give a little bit of a partial answer, and I wanted to be able to walk you through these little concepts. It'll give you an idea of why appeals are difficult. But not impossible, and why they're an important part of our case. And, of course, when we get back, we'll talk to JD and Sky as well. Carl Rominger here on WHP 580, 540-0580. See you guys after the break. Hey, welcome back. Carl Rominger here, 540-0580. Callers, we got on the board here, but I'm going to make you guys wait. So Sky, JD, Greg, hold on. Okay, we're going to talk about the concept of the appeal. We had a guy call in a little bit ago before the break, wanted to know about generally appeals and can things be overturned on even minor things like a denial of a continuance or a discovery motion, etc. I'm going to give this to you in a way that applies to a criminal case or a civil case for the most part. So this is the general overview. When you lose your case, well, or the other side loses their case and they appeal, hopefully, somebody has to file an appeal. An appeal is basically a request to a higher court, and this is the kind of appeal we're going to talk about here, is when you request a higher court to review what happened below. And so when you come from a court of record, which is the court of common pleas, you don't get a chance to put new evidence on. You don't get to file new exhibits, and you don't really generally call witnesses or anything. You just go on what happened below. So you get the transcript, the exhibits, we call it the record, and the appellate court reviews the record and listens to your legal arguments, then determines if the lower court erred. Now, you can raise pretty much anything that you preserve for appeal. So you can't just go back and later say, I want to raise this issue or that issue. It either has to arise in a way that it's already preserved, or you have to specifically preserve it. So objection, hearsay, and the other side says da-da-da-da, and the judge says objection overruled, the hearsay evidence gets in. You've now preserved it for appeal by saying objection, hearsay on the record. If you just did nothing at the time and the hearsay came in, and even if it should clearly be overturned on appeal, you're not going to be able to appeal it. So that's rule number one. You've got to preserve your errors for appeal. So judges love it when lawyers say, well, for the record, Your Honor, I want the record to reflect, and you give your diatribe about why the judges did something wrong, and for some reason they get annoyed with you when you do that. I've noticed. Next, when you do go up to the appellate court, the appeals court has to then determine what the factual issues in the law are as they apply to your appeal. So there's different standards of review. So if it's a factual finding, if you disagree with the judge's findings of fact, the judge says, I thought that witness was untruthful, or the judge says, I found this other witness to be highly credible, and I believe that the true facts of the case are as follows. If those are supported in any way, shape, or form by the record, then those are going to usually be sustained, because to show he abused his discretion, which is really a very high burden. And I've actually had appellate courts write the opinion that says, based on the record, we would disagree with the trial court's findings, but because it's an abuse of discretion standard, we're bound by them because we can't say that they're unsupportable based on the record, just that we would have decided it differently. So congratulations, Mr. Rominger, you lose. So remember that abuse of discretion, very hard to get over. There's another one called plenary or de novo review, which are on legal questions. So the trial court gets no deference whatsoever on legal questions. So if they're right or wrong on the law, it's just a simple, plain question, and there's no deference to their decisions below. So you don't go, well, the judge was pretty close on the law, so we're not going to overturn it. It's different than the facts. Remember, if the judge seems supportable in any way, shape, or form. And while you're on appeal, you have to assume all the facts are resolved in a light most favorable to the verdict winner. So those are all your issues. So once you get over those hurdles, if you can convince an appellate court, because we got one more big hurdle, we've got that all ready to go. And I'm going to win my appeal because it was clearly wrong, and the law was misapplied, and the judge abuses discretion, and it's so palpable and so obvious, whatever it is, that you're going to win. And the appellate court says, congratulations, you're right. By the way, there's one more hurdle. It's called the harmless error doctrine. So, see, Mr. Rominger, you were right. The judge ruled wrong 17 different times, and you've proven it to us. But we don't feel that those wrong rulings have been shown to be likely to affect the outcome of the proceeding below in a way that makes us feel that it wasn't essentially fair and due process. Therefore, since we don't think that the error was such that it would likely have changed the outcome, your appeal is denied. So that's the big question always, is the harmless error doctrine. You know, when we're trying to train young lawyers on appeals and the things to think about, that's the one they have the hardest time with, because they come out of law school being very legalistic and going, the judge did A, the law says B, therefore I win, that's the end of the inquiry. And the problem is the judge can be dead wrong, and you can be 100% right, and everybody can agree with you, but the harmless error doctrine will snatch victory from your hands every time. Well, not every time. We do win a few appeals. But my point on all that is, so when you talk about little rulings on things like a continuance, or little rulings on things like a discovery issue, or little rulings on a little piece of hearsay here or there, it's likely that the appellate court will agree with you but not find that it's shown that it would change the outcome. So you not only have to find an appeal issue that you can get past that abuse of discretion standard on if it's factual, or de novo on the law, but you've got to get there in a way that will show or convince the appellate court that if they grant relief, the outcome is likely to be different, or at least it so undermines the credibility of the determination below that we should overturn the verdict and send it back for a trial. We have a concept of finality, and so courts are always trying to close cases and get to a final endpoint, and that's the goal. So think about the Obamacare decision, because I'll tie it back into that for a second. Everybody thought it was a great winner for the conservatives because, and one of the reasons was, well, Congress can't do that, and it's unconstitutional, and Congress should have done this and should have done that. Notice the analysis the court took. They said, we agree with you. It's not really necessary and proper. We agree with you. We agreed with all kinds of arguments, and then came back and said, oh, yeah, by the way, it's our job to try to sustain acts of Congress because we presume them to be constitutional. We presume them to be such that we need to try, even if Congress didn't know why it was constitutional, even if the lawyers can't explain to us why it's constitutional. It's our job to go that extra step and try to protect it. And so, once again, that's the other little hurdle you can run into as well. So think about that. If you want to know more about appeals, I'm happy to give you more specific information. JD, you're on WHP 580 with Carl Rominger answering your legal questions. What's going on?
Hey, Carl. Good to talk to you. Look, recently lost an EEO case at the Court of Common Appeals, and then at the next level, which I believe was the Third Circuit Court or something like that. I can't recall exactly. But my question is, or my concern first is, continuing to be harassed and retaliated against with this employer, and I'm bouncing around my options. Do I go back to human relations, start there? Can I take this case and appeal it at the state Supreme Court? If I can, is there a statute of limitations on the case?
So you got a decision from who already?
No, I actually lost the case.
But lost in front of who? The Department of was it with the Pennsylvania Human Relations Commission, or did you lose with the EEOC?
Well, it was in the court system. Once we took it to
Court of Common Pleas.
That's it. Yeah.
Okay. Generally, once you got an adverse verdict there, you only have 30 days to file your appeal, and your first appeal would go to the Superior Court.
Okay, well, we did appeal to some kind of Third Circuit.
Okay,
court.
so you did do a federal appeal to the Third Circuit.
Okay, I thought that was state. I didn't know it was federal.
Yeah, Third Circuit's federal, so you're probably in U.S. District Court and then appeal to the Third Circuit. Now, you can appeal to the Supreme Court of the United States, but they only hear about 40 cases a year, give or take, and they get asked to handle thousands, like 16,000 or something ridiculous like that. So I don't know exactly, I can't tell you exactly how many thousands, but I know that the odds of them taking your case are minuscule, and it's an expensive appeals process.
Well, see, I didn't even realize that, Carl. I thought I was talking state Supreme Court.
Yeah.
So, no, I wouldn't do that. I know that they take on many cases, and this is, you're right, probably minuscule. So that helps me. I mean, it lets me know that my options are less than I thought.
Right.
Well,
yeah, sorry you lost. I mean, hey.
Well, sometimes what I'm learning, Carl, is a loss on paper is not always a loss.
Right.
I don't know if you understand that, but...
I said that recently, too.
If that wasn't the case, I wouldn't still be being harassed.
Right.
You feel me? Okay.
And if you're being harassed and retaliated against for even bringing the claim, that alone creates a separate claim. So that may be something to talk with the EEOC or the Pennsylvania Human Relations Commission about. All right, JD?
All right, thanks a lot.
All right, good luck. 540-0580, Carl Rominger here answering your legal questions. Sky, you're on the air.
Carl, nice show. First time I've listened to you, and you do a good job.
Oh, thank you.
My question's this. I feel like I'm in a donut hole with Obamacare. My question is, when the law was voted on and enacted,
Right.
what aspects of it were actually enacted at the time they voted on it and he signed it? My problem is that I've been denied for pre-existing condition.
Mm-hmm.
I was under the impression that when he signed that document, that it was enacted in law and that the benefits were up front, okay, and that obviously the taxes are on the back end. That's all political, whatever. I'm not a great supporter of the man. Don't misunderstand what I'm saying. That's my political view, period.
It's an interesting question. I think I know where you're going, though, is the idea is what's available right away? And I don't know about the pre-existing condition clause when that kicks in. Because here's the answer. That entire bill is clicked in phases. And a lot of it has to be regulatorily enabled as well. So you've got this massive piece of legislation that's going to result in a gazillion pages of Code of Federal Regulations. You have all different portions of it taking effect at all different times with a general gist of benefits up front, tax on the back end, to throw the curve. You know, they try to claim it's not only going to cost so much over so many years, but a lot of it doesn't kick in. As I understand it, a lot of the provisions don't kick in until 2014.
Would that also mean that the pre-existing condition clause or phase of that law doesn't kick in until 2014? And that would stand to say that the president lied to me as a U.S. citizen and told me that I would be covered. Well, I've been denied by 4 major medical companies for my pre-existing heart condition, which has been United Healthcare, Capital Blue Cross, Highmark Blue Cross Blue Shield, Aetna. State Farm was the only one, which is Assured Health, that picked me up with a higher deductible with a rider.
I'm pretty sure kids were included right away, and that adults are somewhere down the line.
I have this. I've been remarried. I have smaller children now, 7 and a 5-year-old. We had a limited medical plan, okay, that was out of Florida, that really did not have any coverage here in Pennsylvania.
I got to go to break, but I found your year. It's 2014 for when it becomes illegal to discriminate against anyone with pre-existing conditions. Children under 19. It became illegal immediately upon signing or thereabouts.
Yeah, but you know what? Because I had a limited medical policy, Pennsylvania, the PA Fair Care Act, doesn't allow me to get onto their policy because of I've had a limited policy that really didn't cover anything.
Right.
For 6 months. I'm done. I'm in a donut hole. And my 7 and 5-year-old can't be covered because they're not of age to be covered.
Interesting. We have a CHIP program here in Pennsylvania. I don't know if that would apply to them or not.
It doesn't because I make too much money.
You are in the donut hole. Then you know exactly where you are.
Done. I'm done.
All right, my friend. That's the best I can do. Got to go to break.
Thank you.
Hey, welcome back. Carl Rominger here. Just reading Penn Live during the break. More leaks. Interesting. Anyhow, Paula, you're on the air.
Is it Paul?
Paul, I'm sorry. It's Paula from Palmyra. That's what got me. Sorry, Paul.
Okay, yes. If you knew my last name, you would think it's even funnier.
We won't do that to you today.
I know. I just had a quick comment and then a question. I think it's very ironic in Obama world that illegal aliens don't have to show their papers, but American citizens have to get insurance. My question is, I was one of the unfortunate individuals in Lebanon County who's just reassessed everybody.
Yeah.
And they want to raise my taxes $2,130. I bought a new house here in 2005. And their assessment says that my house is worth $77,000 more than I paid for it.
Since 2005?
Yes. So that's over like $1,000 a month.
Well, that's probably garbage anyhow, because that's a great technical legal term. garbage. Because if you want to think about it, the way the market has gone, since you bought it, most people's houses have creeped back a little bit or held steady, but nobody's really gone up.
Right. So it just so happens by coincidence that I had applied for a refi on my mortgage, and the bank appraised my house. And they appraised it for $30,000 less than I paid for it. So the difference between the county is saying my house is worth $107,000 more than the bank says it's worth.
What you would do, you can appeal that. And then,
well, I am. I have the form.
Yeah, you should definitely appeal it. Here's what's going to happen. They'll do an informal appeal, etc.
I did that already, yeah.
But make sure you file the appeal. What happens is you got to get your own expert appraiser. The bank's appraiser is really not who you need.
Oh, okay.
So usually what we do, I know some appraisers, they charge anywhere from $400 to $500.
Right.
Get an appraisal, you show it to the other side. Sometimes that works. Otherwise, you got to have some testimony. But I'm predicting, and I'm happy to. I've done a lot of these over the years. Cumberland County did a reassessment a few years back, and we did a lot of tax. I should say they were very friendly. And so what happened was a lot of them, you consult with the people, they get the appraisal, and then it would get knocked back to a reasonable amount. So we didn't end up with a lot of actual litigation.
Okay.
It was more like, come on in, we'll figure this out, and then the tax office in Cumberland County really liked those people there. So I'm waxing philosophical for a moment.
Right.
But my point on it is, I think Lebanon, and if they take a hard line, is going to get hammered because it seems like, from what I'm hearing, a lot of people are discovering these sticker shocks.
Right. Well, everybody in my neighborhood has the same thing. They all got raised about $2,000, and some of them have hired appraisers.
Right.
But I figured since the bank already did mine, I wouldn't have to do that.
What you want to do, you could talk to that appraiser and say, would you be willing to be an expert witness if need be, and I could hire you for that purpose.
Right. Oh, that's an idea.
Because you're going to need that appraiser's testimony at some point.
Okay, but would I bring him to the next formal appeal, or do I have to lose the appeal first?
Are you in front of a judge yet? I think.
No, I think I'm just going to appear before the county officials.
County officials, yeah. So I don't know what the rules they have set up for admissibility on that is. So I would want to check that, because if you can admit the appraisal without the appraiser, you're fine.
Right.
Sort of handle like an arbitration where we can put it in without the appraiser. In an actual court of law, the appraiser is going to have to come in unless there's a stipulation with the attorneys for the county.
Right.
And testify to the appraisal. And frankly, I would want that anyhow if I'm in front of a judge, but which is also even maybe in front of county officials. That person can come in and tell them, hey, this is obscene. These comparables are not something I picked out of a hat to try to help this guy. If anything, with the bank, we were trying to get the opposite direction, and we couldn't find anything.
Right. Well, he gave me five comps.
Yeah.
So, the square footage, even square footage on the homes.
Yeah, and then they adjust a little bit here and a little bit there. But as I correctly predicted, then your house is worth less than you paid for it. And now the county's trying to say it's worth more than you paid for it.
Right. I mean, obscenely more. I mean, it's not even a $107,000 difference between the two. That's ridiculous.
And so, and now, of course, they're probably doing this all over the place.
Right.
So, but you understand what I'm trying to say with the appraiser. You just have to be careful that you can admit it. I always have people want to come to court and they bring me like a letter that somebody signed, and I have to explain to them, like, this may be admissible if the other side agrees, but when I look at the other lawyer and they realize that there's a letter, and they go, why would I stipulate to that? I can't cross-examine it.
All right. I guess so. I should call them, the county first, and see what's admissible and what isn't.
Well, and I don't know if they're going to give you the right answer or not. That's the interesting question. It's an adversarial forum, potentially, but they may have some ground rules. In other words, they may have a sheet that says, here's how we've set up these arbitrations, or here's how we've set up these informal hearings, or here's how we're setting up our formal hearings. But I would always rather be safe than sorry, particularly when you're talking about So here's the dealio. If you win, you're going to save yourself $2,000 the first year. Now, theoretically, they can reappraise you year after year after year. But I think once you get the value reset, you'll be safe.
Right.
So if you figure it's good savings for just 5 years, you're looking at a $10,000 swing.
Right.
So to pay an extra $500 to have the appraiser sitting there talking to them might not be a bad deal.
So I could contact your office. You'd recommend an appraiser?
Yeah, we'd be happy to help you.
Okay, and then he would come with me?
Well, we've got to work it out with the appraiser.
Okay.
Probably we would recommend you bring a lawyer. I mean, that's usually what we recommend, that you bring one of us in to sit in the hearing.
Okay. Now, I had a friend that did this in New Jersey, and the lawyer charged him on a contingency basis.
Oh, on what he saved.
He saved $2,000, and the lawyer charged him 1/3 of the first year's savings.
Savings. That's interesting.
Yeah.
All right, my friend.
Okay.
All right.
Thanks, Carl.
All right, take care. 540-0580. Carl Rominger here answering your legal questions. Greg, what's going on?
Hi, Carl. I'm the executor of my mother's estate, and she leased a car for a 3-year lease, died 1 year into the lease. The car was totally in her name, and we're having trouble getting rid of it.
Right.
Do you have any suggestions?
I assume the leasing company doesn't want to take it back?
They would, but they give you an auction price for it.
Right. And
could we just, I haven't made the payment for this month. If we just left it, could they come repossess it, or can they come after the estate for the value?
They could come after the estate, could repossess it, and then do the auction, and then come back for any, deficiency judgment.
Okay, so there's no way we could get out of this pretty much clean.
Not per se. The flip side is the estate have some value left in it? Otherwise,
yeah, it's only a 2011, less than 8,000 miles.
Oh, okay. Yeah, so nobody in the family wants to take it over?
Not really. We took it to some dealers who sound interested in it and tell you they can give you so much, and then you take it there, they're not interested.
Interesting. Yeah, I think you're probably stuck.
Okay.
I mean, the estate's stuck with some kind of hit on it, either way. And there must not have been any... All right, I got to go, my friend.
Okay.
Guys, I'll be here, and Jeff, you can hold on. I'll be here for the next hour answering your legal questions live. This is Carl Rominger. The website's romingerlaw.com. If you want to get hold of the office, it's 717-241-6070. 717-241-6070. Go to romingerlaw.com. But, hey, I'm going to be here on WHP 580 for another hour answering your legal questions. So I'll see you guys in a couple minutes.